Good evening. It's July 15th on the Alan Osborne Show. As I said, I'm not going to new BCC issues. I'm just closing up mine. I'm going to go over the county meeting today. It's too bad I watched it to go over the whole thing, but I'll go over the part that I want to show you what's not going on. What you're going to see is the Sandestin issue come up. And Tabitha Howard's going to get up there, who lives in Sandestin, and say her and other people want to know why the BCC hasn't acted on a BCC motion. In 2021, the BCC made a motion to give the staff 60 days to prove they were compliant with the state letters from 2014, 2007, 2009, 2010, the special master's hearing, the Florida Board of Engineers findings, and so on and so on. It hasn't happened. And Clay says it was dealt with behind closed doors. Well, it can't be, because it was a motion before the public. Now, Clay says they can't talk about it, but he clearly tells the BCC, who wants to talk about it, that it's their policy. But you'll see none of the BCC, because Clay's clear about it, you'll see none of the BCC stand up and say, well, let's just change our policy so we can do our job. But instead, they're going to use a policy to try to hide behind enforcing the law. So let's go watch what happens, and I'll give you a play-by-play.
3 minutes, please, and state your name and spell your last name.
Now listen carefully to her.
Tabitha Howard, Howard, and this is the end of the meeting, right? This is all done.
Yes.
Okay.
Yes.
Okay.
We're done.
So, I was just wanting to address and see, has the BCC done what they voted on? And we're going to have to go back pretty far to March the 9th, 2021.
Are you talking about the Sandestin?
Yes, I am speaking. Oh, I'm sorry. I'm speaking about Sandestin, please. Has the BCC done what they voted on March the 9th, 2021? They were supposed to get back with us in 60 days. And I tried many times to have it put on the agenda, but on April the 23rd, I was successful with having it on the agenda. And I'll just read as it says. Tabitha Howard, request discussion regarding Sandestin DRI drainage. Attorney Atkinson noted pending litigation case related to the agenda item. Motion by Commissioner Bridewell, second by McCormick, to table any further discussions on the matter and to allow the board to conduct an executive session regarding the pending litigation. Where are we with that executive session, please?
That was held. We held that executive session.
Okay. And
well, here's the point, and Tabitha doesn't know how to make it. Mike Barker made a motion that the staff have 60 days to answer after that, and they haven't done it. So she's just being cut off because she don't know what the right questions asked. But the question is, and watch Clay say this. Look, the board is in possession of letters that have nothing to do with the litigation. In fact, had the board acted correctly on their 2014 letter, they would realize that they shouldn't have a 2017 challenge laying in the court for 7 or 8 years, because that 2014 letter tells them they can't do it unless they've had some hearings. They haven't had them, and Matt Carpenter has broken the law. So Clay, go ahead and explain your bullshit.
I was tabled back then, so how do I move forward?
The litigation's still pending.
What
litigation
litigation?
is still pending. Mr. Osborne's.
Mr. Osborne?
So Mr. Osborne's litigation on whether other people have standing in an NOPC is going to stop them from answering her question of is it in compliance? Listen, they've got years of letters prior to 2017, and they've got a letter from their county engineer, because listen to the stuff they bring up. Well, who says? And Donna, who's received 2 or 3 hours of briefings on it, when she ran for office, she said we had to do something about Sandestin's noncompliance over drainage. Over and over she said that, but she's been silent in office. So listen to her answers.
Litigation is pending, so I can't move forward until I guess move forward with the drainage standard in Sandestin.
Well, here's how they're moving forward, Tabitha. Only you, me, and other people from Sandestin can't talk about it. A developer can still keep applying, and Matt can still keep violating all the letters and findings that he's had because they're allowed to talk. In fact, Danny Glidewell let a engineer have a dissertation in front of the BCC about drainage standards for 30 minutes. It just happened to be a night that I wasn't there. So it's allowed to be talked about when the right people are not in the room who have the information. And so the policy really about litigation is so broad that they just interpret it every way. But what it really means is the people who disagree with the county staff, they're not going to be allowed to talk. And the people who want to keep developing, they've been waiting for an answer for 20 years. In some of the places, they've completely built it out while they didn't know if they knew what the standard was. So this is BS, and more importantly, Clay says it's the board's policy. So it's Danny's even in on it. So only Tony's not with it. They easily have 4 votes to talk about the Sandestin drainage standard, but they're going to hide behind their own policy. Their job is to enforce the laws and standards fairly and to legislate new ones and changes. And that's not happened here. So you can't have a policy with any type of morals that lets you break the law and cast other people into litigation just to hide the staff's mistakes. So go ahead.
The issue is the county will certainly, you can certainly meet with county staff, Ms. Howard. You can certainly talk to planning. You can certainly talk to.
Well, I've done that several times,
but in terms of public comment, just give me a moment here. In terms of public comment, our rule says public comment is not available in matters of pending litigation. And unfortunately, as I discussed with the board in executive session and explained to several times, that is a matter of pending litigation. So, you say you've gotten code enforcement and talked to planning. I think at this point, perhaps.
But y'all are still approving permits on it. But you're still approving permits, and if they're not in compliance.
What did planning advise you about their compliance?
I'm sorry?
What did planning advise you when you asked for compliance?
So let's get this straight. Planning is Matt Carpenter. Let's go through who says they're not in compliance. The State Department of Community Affairs declared them not in compliance. Actually, it was declared the first time in the 1980s, and they settled a lawsuit and adapted a new ordinance in '89 that they would follow the law. So that's the first time. They got put on notice 8 years later that they weren't following the law in 2007. So the DCA, in letters from 2007, 2009, 2010, 2014, told them, when it became the DEO, told them they weren't in compliance. And violations were occurring. A special master told them. They hired 2 companies, Tetra Tech, and they hired Dr. Harper after the special master hearing. And he ruled that the county was meeting not the standards they had adopted. And that on county property and the developer property, it was only meeting 10% and in some cases 0% of the requirement. And so, that finding was appealed to the Florida Board of Engineers. Now, Donna's going to say planning told her that Sandestin's in compliance. But Donna, planning has the 2019 letter from the engineer who says it isn't, and they got to change it because he's saying you got to make it match what you're approving. And right now, the law is not what Matt Carpenter and engineering are applying, and it's admitted in the letter. So go ahead with this phony baloney explanation.
Honestly, it's just the runaround stuff that I always get. I'm going by the Harper's report.
She's going to file a case. If she wants to file one, we'll address any of these issues. But in terms of
Clay, I filed 6 code cases. It was then referred to Wade Wilmoth, who didn't put it into the system. It was then handed to Stan Sunday over a year ago, who then gave it to Michael Gainey, who Stan declared everybody was conflicted and that Gainey didn't understand those state letters. Well, everybody else understood them. Maybe Gainey doesn't need to be in that job. Oh, Gainey would have to find Corman at fault because Corman dismissed them. We've got 6 or 7 complaints that I can show you were dismissed, and you're in a lawsuit with somebody else over one of them still. So quit telling us this BS, because it doesn't hold water if it's examined.
The discussion at this stage right
So
now.
everybody has everything. Because back in 2014, actually, please complied with that letter back in 2014, please.
Yeah, but then let me just explain to you. I have met with planning and a bunch of the people. Wait, let me finish. Sorry. I've met with a lot of people in there and went over all of that information. And then after that meeting, I spoke with Mr. Sunday and said we've got to do something and get this complete.
And we haven't done anything, Donna. And it doesn't matter what you talk to the staff about their violations. They can't override the state or the law. What are you waiting on? Why'd you talk to Mr. Sunday about it? The letter's addressed to the Board of County Commissioners. And if you did that, how come you were too sorry to tell me, the person that helped put you in office, the person that you said that you were going to do something about, the person that gave you the briefs at the Mosquito Commission when they authorized you to go to the state? This is the biggest BS answer, and Donna, that's why you're going to get put out of the seat. Just the way Danny pushed you around and you couldn't tell the facts, you couldn't tell Tony, well, your aides wouldn't be running around naked as Tony questioned you about needing yours. Your willingness to try to make it look good over the facts does not hold water. It's a sieve. So nobody wants to hear. All those reports tell you that the planning and the county staff's using the wrong standard, and who did you go ask? You didn't ask the state to issue a violation if somebody couldn't prove it. You went to the same people who were accused of doing wrong. I mean, Mac lost his license, and have you read your affidavit about what you said about Mac over code? It's ridiculous for you to tell Tabitha that answer. You should be ashamed of yourself.
And he worked on it, and then he worked on it with other people, and then he did call Mr. Osborne, and from what I'm told, Mr. Osborne decided to go in a different direction.
No, Mr. Osborne couldn't get an answer out of Stan after a year, and he said I'm going in another direction too, but it doesn't relieve Stan and the county from processing my code complaints. He just simply didn't do anything, and I've turned it in for another investigation. And finally, somebody's investigating it. And right now, Donna, it says you, Brad, Tony, and Danny have all this information and refuse to discuss it or enforce the law because you've already appealed it to the highest. Your own engineer has told you have hearings. What don't you understand? Go read the 2019 letter, Donna. Maybe if you'd have talked to the people who knew about it, the constituents, maybe because all you do is listen to the people you once said you didn't trust, and the rest of us that you were out here standing with, you forgot who we were. We won't forget the next election. I won't be there, but I'm going to make sure everybody knows the truth, Donna. It's not vindictive or mean like Suzanne thinks it is, and Brad with the hurt feelings report. Asking you to do your job is not a favor. It's an expectation of government. We've all just been sadly disappointed for years.
So we can't do anything about that.
You absolutely can do something about it. You've been given a draft letter. So you can't do anything about it because Stan said that I said. Tell Stan to show you that in writing. No, what I did was cuss Stan. Maybe you should worry about Stan's, like I said in that email, Donna, I bet if you buried those reports in Tony Anderson's aide's underwear, I'll bet you Stan would find them. I bet you he could understand how to get in there and find them then. What do you think? That's the biggest bullshit answer I've ever heard. Don't y'all ever forget Donna John sat as the chairman of the BCC and said, because Stan said so, we can't do anything about it. Those letters from the state for you to do your job, they're not from Stan. They're from the state. And right now, Donna, that letter sits addressed to the chair of the BCC, and that's you.
Mr. Osborne, I'm Tabitha Howard.
Amen.
I want to know because I live in Sandestin. And you know what? We've got things collapsing. We've got the sewers that are collapsing. We've got water stuff that's collapsing. We're sinking.
Watch Brad fidgeting. He knows he knows. You know it, Brad.
in
there's an
compliance, and we are in,
if there's an NOPC, I think that might give us an opportunity to look at things better.
Listen, there doesn't have to be an NOPC. There should be an NOV, a notice of violation issue. Their argument is because the developer doesn't bring it up, they can't evaluate it. What kind of monitoring is that? What if you were flying down the highway and you knew that the 55-mile-an-hour zone had no police? Nobody would slow down. They only slow down because people get tickets. And you're not issuing tickets, and so they're not going to report themselves. That's the stupidest thing. That maybe if he reports himself, we'll have a look at it and see if he's in compliance. You've already had a look at it, and a state agency has told you it's not. What do you mean maybe we'll have a look at it? You spent $700,000. You had an NOPC that 2014 letter, that's a service of planning. It says don't provide those by Florida statute. This is ridiculous. You can only say that because I'm not at these meetings, but I'm watching.
All those would be matters subject to public hearing that we can take up at that time. So certainly any change that comes forward, public hearing at that time is part of the public hearing.
Meaning we might build 5 more high rises and continue to build a bunch more houses and take a bunch more applications. But if they ever put in a change, why would they? They're getting what they want by breaking the rules. This is crazy. So and we put in code complaints. Clay, you're on record of having a conflict with Sandestin, okay? Stan says the whole staff's conflicted, all right? Y'all have lost to every agency you've appealed to on what the standard is or what your calculations are. Bob Horner, your old engineer, agreed that y'all had to meet the standards. Greg Graham quit and still told you that y'all need to have the hearings, but to have the hearings, you would have to admit what the standard was, and if that was the case, it means you lied to a court, you lied to banks, you lied to the public, and that's what they're really trying to protect. And that includes Sand, because in 2016, he sat in a settlement that's public record now and looked at that letter, and the county walked out on a $100,000 offer to settle, and after reading that letter, they offered over $1.3 million. That letter has weight, and do your job, Donna. Don't make it personal like you have on me, or I'm not making it personal. I'm just pissed off and telling you the truth that you lied to us about what you were going to do, and you're at the plate. You've got the bat. Right there's the administrator, and if he don't want to do it, you, the BCC, sign that letter to the secretary that it appears to be in violation and send it, and let the state decide. As soon as you pull the trigger, it's out of your lap. Give them the facts.
But as your rules say, even that matters subject to public hearing, not subject to public comment outside of those hearings.
So he just said that the old BCC who wanted to silence everybody said matters subject to public hearings are not subject to public comments. Well, you're restricting free speech. Y'all don't have to comment on it. Now you've decided we can't even speak about it. Well, why? Because you don't have to comment and you don't have to action. If that's what's on our mind and we want to speak it in the public comments, it's like the stupid policy that you can't make a public comment unless there's a motion. Again, not a law. It's the policy of the good old boy boards from the past, and these people don't want to take it up. They don't want us to speak, and this is proof of it. They're using the policies of the people they said they weren't like against us when they have the ability to get rid of them.
In 21, when you were told, maybe Clay can answer this, but when we were told, I guess, from the board that we'll come back in 60 days, were we under litigation at that point?
Yeah, that's right. There was a damn shitload of litigation, and all the same players were in place as far as litigation goes, Dan. But it didn't matter because the board made a motion, and this policy of litigation does not say that the staff is not required, and they made the motion in public, so it couldn't have been handled in an executive session because it was a public motion. Something smells like this. It smells like the Tony Anderson's office does.
Proceeded through that point, and an appeal was filed during that window. So there's various forms of litigation that have advanced. And I just wonder.
Yeah, various forms of litigation, but it doesn't change the litigation was already in place. What bullshit? You're being taken, Dan. You're smelling the right thing. And how come What about the 3 years between 14 and 17 and the fact that the 14 letter says don't have an NOPC unless you address these things, and they didn't do it? Mac just didn't do it.
Why we would say that from a board standpoint if we were under litigation. I don't know who said that.
Mr. Atkinson did.
Oh, okay. I thought it was I thought it was Mr. Nick.
Well, actually, was that when you actually
It was Mike Barker who made the motion, and I've got a show on it back in the history.
started? Because I know Sydney was
That was
your...
around the time I
That was,
started.
that was your hire
predates
date.
me by
He became our interim that day, actually, if I recall. Yeah. You became our interim attorney at that time.
I'm sorry, it's just a question.
Yeah, that was the day. Yeah.
It's a great question. Barker made a motion. What's the results?
Because, you know...
Look at Brad fidget.
Any of us. So, and I always get confused as HE hockey sticks.
You know why you're confused, Brad? Because you're sorry, but you've had this documentation since 2010 as a state legislator. You know why you're confused? You spent too much time drinking beer with Stan. Those letters are very simple, and I absolutely do not buy the story that somebody who sat in this state legislature and takes credit for passing bills and laws and legislating cannot understand 5 letters saying that you're in violation from state agencies. He can't read the conclusion of Dr. Harper's report about Driftwood Estates, which y'all just approved another development in it for the same guy that sued you. You can't read those conclusions. You can't read that, Brad. How is it confusing? The Florida Board of Engineers has said the staff is using the wrong standard. No, it's not confusing, Brad. It's real simple. What's confusing is watching the staff and SDI try to claim that they have a form of methodology that results in something different. And here's the bottom line. It don't matter what methodology you use as long as you meet the written, adopted, lawful standards. And they haven't done that. And you have all the information, and you just don't want to do something with it, Brad. You just don't want to. Remember, like you wanted me to run for sheriff, but you didn't want to get out there and hold my signs, even though I held yours and put 23 of them in the ground. I didn't want a damn favor. I don't need to buy no friends. I just thought you might actually follow your oath, so I supported you. But boy, that's like a fart in the wind. And you just heard Danny said he don't agree with it. You got 4 votes up there that say they want to fix it, Tabitha, but somehow none of them have the intestinal fortitude. Only Curry smells the rat so far. Dan, you're going to have to lead them out of there, because Brad needs to put down his beer glass and read the damn documents I gave him 20-some months ago when he was appointed the first time by the governor. Wasn't that strange? So the governor supported Mike Atkinson. You should have told him that, Brad, instead of wasting my time.
When this comes up, because
it costs me a lot of money, because I'm having to pay for a lot of the drainage mistakes right now, because my assessments and things go up.
I'm trying to understand, like, okay, there's something that's being litigated, but then outside litigation, there's an expectation that...
Yeah, outside of litigation, which is a civil matter, is the people intentionally breaking the law and causing that litigation. It's not an expectation, it's a requirement of government to enforce the rules. And it's the expectation is exactly what you said you ran for office for. Okay, there's been a motion, there's been findings, there's been a special master findings, and none of you have asked where my code complaints got dismissed. Hell, Donna wrote an affidavit that Mac admitted that Carrot Top broke the law next to me, but he basically wasn't worried about it. She ain't doing nothing about it. And this whole crap with Nathan Curvin resigning so we don't have to hold Stan responsible. I can't even get into this show about the previous thing, but for Danny and Tony to chastise about the AIDS after what's happened, I mean, I've heard threats about all this shit. I mean, I heard Danny's AIDS on the outs with the county. It's what I hear. And Tony's aides are always winding up naked and dragging into lawsuits. I mean, was that a qualification? Tony, you said you wanted to read the job descriptions. Did yours include move naked people around or get drunk and pass out? Was that in the job description and have the county employees deal with it? This thing's just a shit show. But they owe us answers.
that we do something, or that we are committed to do something, but then we didn't do, or we were supposed to send it to another agency, and then that agency sent it back to us. And Mr. Osborne, he goes through this almost every meeting, and
yeah, and you make it confusing on purpose. Read the letter from the state that you're in non-compliance and report the violation, Brad. Report it. Yeah, I go through the same thing. You've got the draft letter in your hand. You done talked to Suzanne about it. Y'all all whispered about the dirty secret. Pull the trigger. Do your job. Stop this BS.
God bless him, but we don't all understand, or maybe I shouldn't speak for.
God bless him. God bless my ass. I sit in court every week. You stop pulling out the Bible with that crap, okay? God's not in this right here, okay? Do your job. If you can't read a 100-word conclusion from Dr. Harper, if you can't read a 3-page document from the state, if you can't read the Florida Board of Professional Engineers findings that are very complicated, but the conclusion says the county's applying the wrong standard, if you can't realize that MAC is breaking the law, then step down. Do us all a favor if it's that complicated, because you don't want to sit down and have it explained to you. You don't want to offer to have it explained, which you had for 20-some months. You told me to take it to Stan, and Stan's telling y'all I don't want it actioned, while you sit here and admit I come all the time asking it to be actioned. Your words are just as big a sieve as Donna's, Brad. Grow the hell up.
Everybody, I don't completely understand every facet and component of what is under review, what's not.
You don't need to. You just need to know that you're issuing development orders in violation of your ordinance. That's all you need to know, Mr. Legislative Body. You don't have to understand the engineer, and I know your judgment's clouded by alcohol, probably.
Not under review, what can be discussed, what can't be discussed. If there was some.
Anything that can and can't be discussed is because of your own damn policy. Again, there's no law about elected officials talking about a law being broken and how to enforce it. There's no law. There never will be. That's only goes in the phony baloney Walton County that has the highest paid interim attorney in the state for 3 years in a row, probably ever.
Something that specifically was asked of us that this board had oversight over to make a determination.
Listen, Brad, specifically, the state sent you letters, the 2014 one being the culmination. Do this and adopt the standards that you're using anyway illegally, or don't go forward. The state gave you a do-out, but your vision and your brain is clouded with BS. Get down to the truth. Like you said on that earlier stuff today. Don't preach it. You're gonna talk the talk like you did earlier in the meeting. Go walk it.
Or review whether or not it was within the confines of the constructs of the law. I'm willing to do that. I don't know what that is, so if you could.
You're willing to do it. You possess the letter that tells you exactly what to do. You've got all the information, but you want this poor girl in there to explain it to you, the legislator, who has a very directive letter sitting in his possession and has for a very long time.
Would you tell me what that is?
I don't have the numbers or anything in front of me right now. I didn't even know I was going to talk about this. But just
Brad, she already told you the numbers earlier. She said she's got a 2014 letter telling you what you've got to do, and it's addressed to the BCC, and you haven't done it. She already told you, but you weren't listening. You were probably surfing on your computer or had your hands up on your head thinking Epiphany's going to come up there and give you the answer. Open your eyes, open your ears, and look at the people who are talking to you. And if you don't understand it, go meet with them. Invite them to your office to explain it. Invite the county engineer. I'll explain. Do an announcement of a public meeting, and all of you come, and I'll explain it one-on-one versus your county engineer with his own information. I dare you.
I don't know exactly what the numbers are. We're supposed to be at a 24-hour, the 6.7 inches or what. I can, you know what, you want to sit down?
What are you asking us to explain what you want
I've already explained it to you, Brad, but go ahead and keep beating up on the girl who's confused. Go ahead.
us to consider?
I want you to consider what the drainage standard is supposed to be for Sandestin. It impacts both the Gulf and the
You asked the
Bay.
question. Now let me ask the attorney. What flexibility do we have to make that consideration?
That is a question that is fundamentally an engineering question, and the county engineer, I'm sure, can give an opinion on that. I believe the fundamental issue we find ourselves in is this matter is
Does
initiated.
Chance Powell, does he think that Dr. was right?
So, as a fundamental matter, the county went through an NOPC about 8 years ago. That's subject.
And there's nothing in that NOPC about drainage. There's nothing in that NOPC that's about whether they have to enforce the law given to them in 2014. Nothing.
But at the end of the day, the time to make those appeals, I've said this executive session, I'll say it again now, the time to challenge those original approvals, including to the board with the state of Florida that deals with water issues, that we talked about, did not receive.
The board that he talks about has no oversight over the DRI. Only the county enforcement and the Secretary of Commerce under a old section that was absorbed from the DCA. Okay, this is BS. This is a DRI. It's an ordinance, and so some other board cannot overrule a county. The Water Quality Board has not been told the truth, and Clay knows it. That's part of the appeal.
Any challenges or appeals from anybody in Sandestin or anybody outside of Sandestin.
But they've taken new application and approvals knowing that this issue is out there. Why? The law is still on the books, and they're using policy not to discuss it.
The court in Walton County, as a matter of public record, has clearly ruled the time to address all that's gone. So, from the county's perspective, at this point,
listen, the drainage compliance and eliminating it is not part of this NOPC. So no matter the outcome of this NOPC, 8909 and the settlement agreement and the standards adopted in the application for development order for drainage that Tabitha's talking about will still be in place no matter the outcome of this NOPC that Clay claims.
Unless our engineer stands up here and says, hey, I have a different opinion of drainage standard, we cease as compliance is what I believe our engineers are saying.
Nope. Your 2019 letter from Greg Graham says if we want to use the standard that we're applying, we're going to have to change the law. So your engineer already said that you're not in compliance because he wants the law changed to match what they're using.
Now, an opportunity to review that may well come up during future NOPC, during future hearings about Sandestin, should they ever make future changes. But as of right now, we're in the First District Court of Appeal about whether or not that's going to come back up again, because that was part of that litigation that should have been addressed. But in terms of what the county views the drainage standard is, unless the county engineer comes up here and says they view it something different than what we're applying, that is how they're applying it at the point in time.
Listen, Bob Horner already declared that specifically, and I had the email for y'all fired him. And Greg Graham told you had to change it before he quit. So sorry, Clay.
And I will reiterate exactly what I said to this board when we had a matter come before us in the planning, and we had third party engineer, we had from an applicant. Better than time on all of this. Much as this has been discussed legally, the whole point about Ms. Howard, with all due respect to what you're trying to talk about, I'm just reciting your rule. You don't talk about the litigation.
So Clay just admitted another engineer got to break the rule for 35 minutes and opine about it right in front of him and the BCC, but I wasn't there. But now he's saying it's your rule that she can't talk. Do you smell the stench of dead fish in this meeting?
You can go talk about it with citizens if you want. That's your discretion. I can say, hey, look, it's a bad idea to do it, but it's your call.
Exactly.
She can tell our staff. It's just in these meetings. But we're stops in the...
So Clay just told the attorney, all the commissioners, that they could talk to the staff, which is exactly what the grand jury said, don't interfere in day-to-day operations. So there's another confusing point. Keep going, Clay.
Because as I've said several times, I've pointed out that meeting. That's why it's an engineering issue. When that engineer presented the board, drainage standards, curves, slopes.
The bottom line is they hired 2 engineering companies, the state engineers. They've got it, and they just had an engineer agree with Danny. The standard was what I said it was, and so that's what they applied when they approved the Moxie Hotel. Like I said, they're all hiding behind policy. Look at Brad, head down, just wants to hide. I would too if I were you, Brad. If I had no more guts than to deal with this, and it's just BS, like I told Larry Wayne. You just don't want to deal with it.
That's not what your attorneys do. That's what your engineers do. So to me, this is purely an engineering issue, and perhaps it's something that would be well advised for the county engineer to come around and meet with each of the board members to make sure y'all understand the county's position on that, because this litigation will be over at some point. And when it is, we'll have these meetings, and
So they just said no matter when this litigation's over, we'll get to talk about it because the drainage isn't in the litigation. He just said it's related. It was BS. It was passed as a gag order so they could approve more high-rises in Sandestin by claiming they had an exception by meeting these previous standards, but they weren't meeting them.
we'll have to talk about rule and stop it. So probably a good idea to get you to talk to all of you about that before we get there. But not today in this meeting, I don't believe.
But they could change their policy and do it right now, but they won't.
So that me too. So
I would like to just point out I voted against that for the planning commission and the board. So I'm the only one up here that did that.
Well, good, Danny. You shouldn't have a hard time voting to send the letter to the state since you're so proud that you was in non-compliance that you voted against it. I'm glad you've admitted it because you wouldn't before.
But you won't. Sure, Mr. Matthews in the back. To hold
Welcome to the county buffering.
that against me. But
The bottom line is, I'll wrap it up, is they don't do a damn thing. They don't change anything. They just sit there. And there Brad knows he's had the information. He knows that they can't prove it. He knows the highest engineers in the state have said the county engineers are using the wrong standard. And the 2 county engineers, one's been fired. There was another one too, Ryan, that would have told you. And now Greg Graham going out the door. Hey, you better have these hearings. And it goes to the fact, why did we ever have the other MDCs if we knew we weren't in compliance and a letter directed the BCC not to do it and underlined it, Brad Drake? And you've had that letter, Brad Drake, for at least 20 months. At least. You've done nothing. Don't tell me about it. And that's the way it was on January 14th. God, I'm glad I won't be in the middle of this mess no more. I'm just closing it out the door, but I'll tell you the truth, and that's how it is on the Alan Osborne Show. Sometimes you can't reason with people with the facts. They just want to go on with what they got. You know, it just is what it is. So, until next time, I don't know when that'll be. I'm Alan Osborne, but keep these commissioners straight. They don't want to take responsibility, and they don't want to take the lead, and that's exactly what they were putting in the office for. Right there, Curry's your only hope. He already smells it. And look at Clay. He's got to pinch his nose for the stench. And Brad knows he is screwed to pooch on this one. Donna, no credibility. Quit laughing like Kamala. It's driving us all crazy. Quit being pushed around like a rag doll up there. Till next time, I'm Alan Osborne. You can't make this shit up. I'll see you.